Hi again, I'm attorney Ashley Sherrick, owner and founder of Sherrick Law Office. I'm back today with another quick Q&A in our Ask Ashley series. Today's question is, what if you pass away without a will? So if you pass away with no will in place, Pennsylvania law fills in the gaps. So state law will dictate who gets what if you have not clarified in a will who your heirs and beneficiaries are. State law tends to follow kind of what you might expect people to choose. A surviving spouse is the primary heir, and then children after that. If you do have children, whether from your current marriage or a prior marriage, it can start to get dicey very quickly with who will inherit what from your estate. If there are no spouse or children living, then it goes up to your parents who would receive your estate. And then ultimately your siblings, nieces, nephews, aunts, uncles, cousins, until someone is available to receive your estate. But it can get really tricky if you have a blended family or either of you has a surviving spouse that have children from a different relationship. Because the numbers can get a little tricky and don't just go a flat 100% to blank or an equal shares in that case to your heirs. So even though Pennsylvania law does fill in the gaps to make sure that people who are close to you will receive your estate, it might be different from what you would want if you wrote it down. And it also doesn't clarify who is in charge of the assets left to a minor or an incapacitated beneficiary. So state law is really just following the family tree, but really doesn't do a whole lot more than that to make sure that those who do receive your estate receive it in a way that you would want, and maybe at specific ages along that way of how you would want things to be distributed. So if you die without a will, state law fills in the gaps. But even then, it's really important to make sure that your plan is laid out in writing so we're not having to rely on state law for you. See you next week for our next Q&A.